This is an appeal in the matter of Buzzard-Quashie and the Chief Constable of Northamptonshire Police.
Good morning, Mr. Laird.
May it please the court, in this matter I appear on behalf of the appellant with my own friend Miss Elves, who sits behind me. The appellant herself sits behind her, Miss Buzzard-Quashie, who's, as you see, come to court today. The respondent is represented by my own friend Mr. Gold, who sits to my right, with his, I believe, instructing solicitor. I don't believe there is anybody else from the respondents here in court today. Lady, I wonder if I could just catch up with where we are document-wise.
Absolutely. I was going to ask you to do the same thing.
Never normally attractive to start with administration, but it may
But
save
in this
time.
case, yes.
Yeah. So we have originally in the core bundle a skeleton argument from the applicant and a skeleton argument by way of response from the respondent. And just so you're aware of those relevant documents and page numbers, the appellant's original skeleton permission stage appears at your bundle page 16 of the updated core bundle. And the Learned Friends skeleton argument appears on page 95 of that bundle, which was served, as it were, in more than one sense, responding to the appeal, also seeking to rely on fresh grounds, which application was in due course refused by Lord Justice Lewison. We then have, bringing matters up to date, an amended, or rather a further skeleton argument from the appellant, which I hope the court has got. It's quite a lengthy document, page 27
pages.
That looks very like it.
That's it.
And contains with it, if I might say so, largely the industry of Leonard Jr., who, having been served with a schedule of material from the respondent in relation to purported compliance, I'll put it no higher than that at the moment, deconstructed it effectively.
Yes, so it's your analysis of that further information apart from anything else. And then you've sought to amend the grounds of appeal.
Then there's an amended ground of appeal at ground 6, which reflects the fact that by the time that skeleton argument, we had been informed that a piece of video footage from an officer by the name of Rideout, which I may say the appellant herself, when in person, had been asking for months and months on end, if not years, had been finally discovered by the respondents, only as a result, I may say, of Milena Jr.'s industry in telling them what the schedule that they served actually showed, as opposed to what it didn't. And our concern in that regard is obvious. We then had, along the way, we thought appropriate to provide the supplementary bundle, which included that schedule of some 1,200 pages. We also provided 2 witness statements that have been served on us from Mr. Staples, the respondent's solicitor, to some extent in an effort to prompt them to make an application to rely on them, but we obviously seek to rely on them in any event. And then next in turn, we provided a note of Monday which drew the court's attention to the fact that we had received a partial admission, as it were, from the respondent in relation to what was paragraph 3 of the original order of the district judge. Now that note is dated the 21st of October and was supplied early yesterday morning.
I'm not sure I have that.
I'm not sure I've got that note.
Well, now my lord and my lady have confirmed they're not sure they have it. I can definitely say I haven't.
Well,
I've not seen it, put it that way.
having
I may
reminded
have it, but I
ourselves,
haven't seen it.
despite the electronic days, we still need to carry some paper copies. We have paper copies, I'm told.
And that's also the 20th, is it, Mr. Langley?
21st.
21st.
So that was yesterday,
That was yesterday.
but it draws attention to the partial admission that had been made a few days before, and I'll take you through that now if you haven't seen it before.
Thank you. No, I haven't seen this.
I say, as I know my instructing solicitors here, that I'm confident it was filed, but these things happen.
No. I'm sure it was.
Yes, indeed. So can I just draw your attention to, first of all, paragraph 2. On Friday the 17th of October at 4:15 in the afternoon, 7 days after the schedule had been received, we had an email from the respondent solicitor saying, and I quote, "Enclosing a sealed application, sir, for the defendant in relation to the witness evidence, does the court have it for the purposes of this action alone?" Not quite sure what that means, but there we are. "The Chief Constable of Nottinghamshire Police is prepared to admit contempt in relation to the limb of the appeal that relates to the provision of a witness statement from an officer of inspector or above." Now, we relate that to paragraph 3 of the original order made by District Judge Leung, where effectively that is what he required. On the way through, I hope the court will allow me this observation. The only sensible interpretation of District Judge Leung's Order 3 was that the person making that statement was to be a police officer of a rank of inspector. Any other purported interpretation of that, we respectfully suggest, is completely bogus and a smokescreen under which to try and explain what the respondent has done by reference to a lady by the name of Trina Kitely-Jones. So this note,
Well, I'm not even really sure what it means. I'm not unclear as to what your note means.
yeah, thank you.
I'm unclear as to what the email that you got on Friday means, actually.
If I might say so, we are at one on that, my lord. The first bit I don't have to say I don't really understand is for the purposes of this action alone, because in my submission you're either in contempt of court as a matter of public record or you aren't. Trying to limit it in that way, again, some would say was a thinly disguised smokescreen of unattractive hue in order to try and...
Unless there are 175 other applications where the Chief Constable of Northamptonshire has acted similarly.
Well,
and so they're just trying to limit it to this one.
my lord, I'm not sure I can answer that question without sounding facetious.
No, I understand that. But
I
mean,
follow the observation.
we take the point that it can only be contempt, as it were, in these proceedings, but that's all your client is concerned about.
Indeed, but also concerned about that being a matter of record, public record,
Of course.
in the public interest, which is plainly engaged, as well as her own interest, because it recognises the failure about which we complain.
But I assume that the intention is to limit, maybe not, the admission to the rank and nature, status of the person who gave the witness statement, rather than the content, the evidence, the detail.
My lady, I hope I can just say I don't know, is the answer. That would be a matter for my own friend to explain.
Yes, we'll
But
have
it-
to ask Mr.
But it's
Goldberg.
capable of more than one interpretation. But I didn't want to take you to that without saying with as much fortitude as I can muster that this was always a case that required a statement from a police officer of the rank of inspector, and that is the only way that can be conceivably, at least the rank of inspector, conceivably interpreted, and not a civilian employee, which is the most we've ever had in effective attempt to explain, even though it couldn't conceivably be.
Well, it also, the paragraph 3, which you said of the district judge's order, actually has 3 components to it. The first is if the video footage is not available or disposable.
Yes.
That's the first one. Then there's the rank of the person making the witness statement.
Yes.
And then there's a statement why that video evidence is no longer available or disclosable.
Yes.
And I'm sure that's probably part of the reason that you're not sure on the text of that email what limb of the appeal is actually identifying. Is it the
Indeed.
rank only, or is it the other parts of paragraph 3?
I know not.
No, I understand. All right.
But may I just make this observation as well? That by this stage, the 20th of October, we've had the schedule and the information that suggests a piece of video has been found, and yet literally nothing from the respondents by way of legal team to help us understand by way of further skeleton
Understood.
what the implications of all this was, because the existing skeleton in the bundle purported to support the proposition that, to all intents and purposes, the order had been complied with, and yet we're being told on the 9th, 10th, maybe they knew even earlier than that, I know not, that it can't have been complied with because they discovered video, and yet radio silence. And I have to say, on behalf of my lay client, who has conducted herself as a litigant in person until Milena Jr. and I came on board at the permission stage, with considerable fortitude, dignity and restraint. And you will struggle to find any intemperate remark in correspondence that she has indulged in over the years to try and get what was rightfully hers. And I have to say, sparing her embarrassment, she deserves considerable credit for that. And all she has received by way of response is obfuscation and misleading material. And I repeat, it was only and only when, through the industry of Milena Jr., I say again, the respondents were literally told what they'd served as actually meant, did they then discover, and this is a further point that will no doubt be developed in due course, yet another piece of video from an officer called Virtue. Earlier this week we were informed of that fact. And frankly, against that background, we make the submission and observation that they cannot have known, or if they did, they were chancing their arm with that schedule in the hope that we would walk away satisfied with that work. And I'm again paying tribute to Milena Jr. She has literally deconstructed it.
Mr. Lennon, I've just got one question for you factually, because it's certainly not something that jumped out at me from Mr. Staples' second statement, which is the 15th of October. You just referred to another piece of video, I think.
Well, yes, that
From
at
Officer Virtue.
the time of those statements, that we didn't know about that. That is a piece of footage that has emerged over, or knowledge of it has emerged over the last 48 hours.
Oh,
Ah, well,
so that's new.
Oh, new.
well, that means it's new to us.
Oh, I'm so sorry.
Well, I'm speaking for myself.
Yes.
I don't know if my
No.
Well, I don't know.
So
if
is
you-
that different to the Virtue 1 and 3, is it,
it's
in the
Virtue
schedule?
2.
Virtue 2.
Virtue 2.
I'm just checking.
I think Virtue. I'm getting mixed up.
Yeah, I'm mixed up.
So the
Oh,
Virtue...
Sorry, I think Mr. Leonard's going to help us. Sorry.
Right, well, I hope so. I was going to say, we've now got and been supplied with the ride-out footage, that which was discovered 10 days ago.
And that is in Staples.
Absolutely. But as I stand here now, the respondents know they have a piece of video footage from an officer called Virtue, and they know that they haven't supplied it to us and haven't supplied it to my lay client.
Oh,
Is that I haven't had a chance to read your note to the court of this week. Is that mentioned in
No,
there?
because we've only relatively recently discovered
I
that.
understand.
And
So
it's
paragraph 50 of your
no.
lengthy skeleton,
the
supplemental
supplementary.
skeleton, that's what I thought the position was in relation to Virtue 2, where it says it's never been disclosed to the claimant on the basis of the second explanation, because it was assigned to the incident, it would not have been auto-deleted. accordingly it should still be on a VM and therefore should be disclosed.
And that has now been, we have now been told that that is indeed correct, that Virtue 2 does exist.
So what's changed now is that 50 was your effectively
Supposition.
submission,
Yes.
and
So-
50 is now accepted as being right.
So 50 might have fallen into the category of paragraph 3 of the DJ Leung order, because it might have called for an explanation as to why it was not available, but it now falls fair and square into District Judge Leung's order 2, because it's been video footage they've had in their possession all along.
Well, there's no witness statement dealing with Virtue 2, you've just been told it exists.
We've been told, but I don't. So,
Are you told, or is it in correspondence?
would you give me a
Yeah,
minute?
of course.
And moving forward on the panel, Malone correctly observes that the respondents filed a note yesterday evening at 5 to 5.
Don't have that.
Well, I don't know if one of our friends got copies of it.
I would hope so.
Mr. Gold, do you have copies of something apparently filed at tea time yesterday?
I have no additional paper copy with me, but I can of course send it by email to either my lady's clerk or to the court.
I'm quite happy to have it directly.
May I?
Yes, please would you send it directly now to Lord Justice Fraser, and then at least one of us has it before the court.
Yeah.
And if you can also send it to my clerk.
And
you're
my
going to-
clerk, with a note to say, please take to judges in court.
Immediately.
So, Mr. Gold, can you guess my email address? Would you like me to write it on a piece of paper? Actually, my learned clerk's over there. She'll tell you what my email address is. Do you want to just go over?
So just draw. So sorry.
So we know there's a respondent's note because you told us,
Yes.
and Mr. Gold's confirmed it. But
And that
what's the
essentially-
headline about?
The headline is that they concede both contempt in relation to paragraph 2 of District Judge's Leung's order and 3, and it'll be him to explain why, and I will give way to him in due course, because quite where this leaves the court today is anybody's guess. And the third headline, if I might say so to my lord, by way of response, is that as we sit here now, they think there may be yet more footage that they haven't yet found,
In addition to Virtue.
in addition to what we have been provided with from the Officer Rideout and Virtue. And that feeds into, as it were, the order that might be made today and the way in which this court might deal with this case, because at the moment, this court does not know how bad this contempt of court as admitted actually is. We don't know just how much footage they have failed to disclose. And I make this further point. As I stand here now, the respondent remains in contempt of court, unquestionably, seemingly by choice, because that Virtue footage has not been disclosed, at the very least. And there is literally no reason why that couldn't have been done. And we are relatively astonished, forgive the hyperbole, that it hasn't been. So if I read the court's possession or non-possession of documents correctly, you have nothing from the respondent apart from the 2 Staples statements disclosing the existence of Rideout, but still maintaining that there was nothing more to give, and that the schedule established that that was the case, and silence otherwise, which was indeed the position that we were in. Malone and I, of course, have been in communication. I don't want to suggest otherwise, but until 5 to 5 yesterday, we had no idea what the public face of this response was going to be to this court from a chief constable of a police force, in relation to whom admissions of contempt of court lasting in excess of nearly 2.5 years are being made. And we regard that as a matter of the utmost seriousness from a public interest perspective, let alone a private interest perspective, and the rights of my late client to have what District Judge Lewin ordered her to have to more than nearly 2.5 years ago.
Gold, have you been able to send that yet?
I'm typing my lord's email address as my lord speaks.
Well, we'll give you a few moments so that is sent through to us all. And then I'm going to ask you to make some submissions and tell us what the present up-to-date position is in relation to your client. But carry on and send us that document, please, first. Perhaps we can just recap on relatively tedious in comparison with what we've been discussing, housekeeping as to where we stand,
Yes.
whilst Mr. Gold sends us that, because we have fresh evidence in the form of Mr. Staples' witness statement, of the last being of the 15th of October. And we then have your response to that, which
Yes.
is your supplemental skeleton and your amended grounds that you seek to amend.
Yes.
So that's where we are. And it would seem, although of course I'm going to ask Mr. Gold about it, from whatever the note said at tea time yesterday, that his position is based upon that further fresh evidence of the 15th of October, but also the analysis in your further skeleton.
Yes.
And so that brings us all up to date. So I think that, although of course I'm going to ask Mr. Gold in a moment, that it will be that we should be omitting, of course, the fresh evidence in the form of Mr. Staples' witness statements, and that we should be giving permission for your additional very helpful explanatory supplemental skeleton. And unless Mr. Gold has anything else, any submissions that he wishes to make about that and about the consequential application to amend your grounds, then it would seem likely that that would be the appropriate route to take. But of course, I'll wait to hear what he's got to say. But I just wanted to clear the administrative, home housekeeping on those fronts before we go any further.
There are indeed potentially a flurry of applications to be made, but if I might say so, my lady's captured exactly where we are.
Yeah.
I'm not going to add PC Virtue's name to the proposed amendment of ground 6, but the court is aware that the way ground 6, the new one, is drafted, of course Virtue could be added alongside the name of Rideout as matters stand. But in view of what I'm being told, namely by my learned friend, that there could be yet more footage as yet undiscovered, in the nicest possible way, the amendment today may need a further amendment at the time of the respondent's choosing. So I'm going to leave that as it is, but plainly the court will take into account the wider picture as and when that becomes clear. And again, returning, if I may, to my lay client, as I think has been already observed, she's been asking for this material very clearly, very helpfully, with restraint and dignity, since before the District Judge Lewin order and since. And one of the key parts in the chronology, in my respectful submission, and something that you probably need to have in mind, is what happened right at the end of the 28 days given by District Judge Lewin for compliance. Because in my respectful submission, that is a key moment at which unquestionably the contempt was complete. It was a deliberate one. Whether or not the individuals concerned knew that that made them in contempt is a slightly different matter, but it's certainly an interpretation. And by that, if I may, I'll invite you to some pages in the supplemental bundle. We know that in the early part of May,
Which supplementary?
the first one, forgive me.
That's right.
Yes, first supplementary bundle.
Can I just check, just
Yes.
while you're getting the page references? Mr. Gold, have you actually sent that document?
My lord, yes.
No, well, it hasn't arrived. But that's, if you've sent it, that's, you Fraser with an S, yes?
Yes.
Okay, well, that's, I'll let you know when it gets in.
And you've sent it to our clerks as well.
I have, my lady, yes.
Thank you very much.
Can I ask you to go to first supplementary bundle, page 110, which is a witness statement from my lay client, dated the 30th of May, which was submitted in support of the contempt application. The court may have noticed that my Lord Justice Lewison observed that it wasn't with a affidavit at this stage, but as I understand it, no further point is taken on that for obvious reasons. My Lord Justice Fraser seems to be, are you?
Well, I'm in a rather large supplementary bundle, but my page 110, if we're using the red numbers.
No,
Oh,
red
no,
number's
we're not.
50.
Bottom right. there's a-
Small black numbers, bottom right, 110.
Not the first time
Sorry.
the Court of Appeal has been given more than one pagination on a single page.
No, that is correct.
Sorry,
I just for some reason this bundle doesn't actually have the black numbers, but that's okay. I can work with the red ones.
So if you, the red one I have is 051.
Yeah, I've got it.
Yeah, it starts at 50.
I don't have the black numbers for some
Oh,
reason.
I'm so sorry
Don't
about that.
worry.
So the background to this is that by then the appellant has applied for proceedings for contempt and a contempt application, and what you see on this page is the lady by the name of Trina Kitely-Jones, who seems to be a data processor manager, who has provided a variety of pieces of, or certainly pieces of paper with her name on it, unsigned and without any witness statements to truth. But let's move on from that. Does the court have paragraph 8? This is the
Yes.
19th of May. So DJ Lung's order for compliance is running out and will run out shortly. I was called that evening, Friday 19th of May, by a manager named Trina Kitely-Jones. I was informed that although she was the manager of the data team, she had the equivalent rank of inspector. I've already made my observations about that. That's nothing to the point. However, Miss Kitely-Jones promised she'd look into the matter herself over the weekend and promised to call me back personally by the end of play on Monday, 22nd of May. I emailed that I offered to help within a day of the hearing, and that is her evidence, and told her about Sergeant Nealon. Just so the court's aware, Sergeant Nealon is somebody she spoke to immediately after her arrest on the telephone, and described in that telephone conversation all the way back at the time of her arrest what he was seeing by way of footage, which made my lay client realise that there was other footage that she wasn't being shown. But let's move on for the moment. She then emails, she says, I also emailed her some images showing that PC Rideout was wearing BWV at the time of my wrongful arrest. Those images are in the bundle. She explained that she would do extensive searches on all the systems and she would speak to Sergeant Nealon. 22nd of May, Ms. Kitely-Jones called me as promised. She explained that despite my picture proof, she checked all the systems. No other officers had uploaded their BWV. I of course asked her why, but she told me she couldn't answer this. Ms. Kitely-Jones also stated she had spoken to Sergeant Nealon and that he could not remember what he had watched. 11. Ms. Kitely-Jones also explains that somehow none of the 7 BWV footage that had been uploaded were uploaded with the original date and timestamps. She said that she herself is questioning this as the BWV automatically records with these elements. She says she cannot explain why they're missing. And then this does the court have, and she was not happy to sign her name to anything, so she was returning it back to legal. That in my submission is a pivotal moment because this lady is purporting to try and comply, let's assume this for the moment, with paragraph 2 of District Judge Leung's order. And she is acknowledging to the appellant and recognising herself that that is not going to be done in accordance with that order. And she's sending it back to legal. And we say, if you ever wanted to plant a flag in the sand as to when a deliberate contempt started, it starts from this moment onwards. I asked her if there was a way that the BWV footage that I did receive could have been edited before it was uploaded to the central system, to which she replied that the police teams at Northampton do have shared drives, but this would be, quote, strictly against procedure. Ms. Kiteley-Jones also promised that the BWV that does exist and that I had already received would be resent to me by the end of the week with the formal redactions, quotes, and then in brackets, as if complying with court order disclosure instead of a subject access request. However, I would not be receiving the missing footage of the cell of all 3 officers involved in my actual arrest because there was no way of her obtaining it. And that would include ride-out, of course, that we know about. Frustrated, she goes on, I explained that I would have received an accompanying document with I should have received an accompanying document with full explanations of what footage was missing and why. By no lower rank than an inspector, but Miss Kiteley-Jones again repeated that as things stand, she was not happy to sign her name against anything in writing, and it would have to wait for legal, and she is sending this matter back to them. And as I say to the court, that, if one were looking for a flag in the sand as to where A, knowledge plainly of the order, well, I don't believe that's sensibly in dispute, but B, as a consequence of that, some attempt, meagre though it is being made to comply with paragraph 2 and or 3, and yet plainly it isn't complied with, and it goes back to legal, and silence then persists. I may say also, if I may, that the first witness statement provided by Miss Kiteley-Jones, which you'll find in the same bundle at 206, I believe.
Black or red?
That's black. Confusingly, although it seems earlier in the bundle, it has 147 on the bottom of it in red.
147 in red, yes.
Lord Justice Fraser, it's about 2/3 of the way through the paper bundle.
I've got 147 in red, but we're going to Ms. Kiteley-Jones.
Exactly. And all I need to say about this is that, of course, by then, the respondents have a narrative account from the appellant as to what the nature of that conversation was with Ms. Kiteley-Jones back in May, shortly before time ran out. And yet, in this statement, although it appears that she's dealing with, or purporting to deal with, events in May, at paragraph 3 on page 63, my Lord Justice Fraser's 147, there is literally no attempt to deal with the conversations that this individual had with the appellant those months earlier.
Well, and you've already made the point, but in view of the passage you've read out to us about her not being willing to sign it.
Well, precisely.
She hasn't signed this either.
It tells you, no, I don't know, I hadn't noticed that before, not even this is signed. But on this, it may be that it's e-signed, I'm not sure, we better be a bit careful.
There's a signature on all 50 on part of it.
On the next page, I'm just trying to link those dates. Yes, perhaps we should be a little hesitant by saying it's not been signed. I don't want to take a bad point on that. Let's assume it was in one form or another, but the point remains the same. That the concerns raised and the issues discussed back in May are simply not engaged with at all, despite, as she says, this having gone back to legal. And what follows thereafter in relation to the county court proceedings, and perhaps, and we would say at least as important, before this court, post the permission being granted, are a series of false statements made by individuals purporting to give evidence to assist both the appellant and the court. And I have a table of those false statements, which I'm more than happy to share with the court. I haven't shared it with my own friend, but it is literally taking sections out of relevant statements at relevant times. But the first of those is in relation to...
Have you got copies of that to hand up
No,
and to
I
give
can-
to Mr. Gold?
I can certainly give copies out. Yes.
Okay.
Mr. Gold, your email still hasn't arrived. So,
My lord, I've sent a second.
I'm sorry?
My lord, I have sent a second.
Who was it sent to last night?
Do you have
My-
it, Elsa?
My
Oh,
clerk's
it's
pretty
been sent
good.
to my, it's been sent to my clerk. I'll send it to him.
I'm sorry, my lord, was
Who was it sent to last night at 5 to 5? Because there are often things sent late and my clerk copies them and puts them on my desk first thing in the morning. This wasn't one of them.
No, only me.
We think it may have gone to the Court of Appeal office rather than any specific member of the court's
Well,
club.
that's the kiss of death.
Never to be seen or heard of again. Well, maybe never.
We'll
That's
get
a little
yeah, I was going to say,
It'll
we will
come
get
next
them,
week.
but it won't be for the
Someone don't
purposes
have
of
their own
today's
previous
hearing.
not me. But yes, I follow the point. May I hand up in the interim the schedule of false statements contained in the papers so far?
Yes, and you've given Mr. Gold a copy of
Mr.
that?
Gold's got a copy, but I emphasise that this is extrapolating from various
Yes.
documents through,
Yes.
so it's not new. And
No.
it's got page references. and
It's
the rest of it.
It's a secondary document.
It's a collation.
It's a collation. Thank
Thank you
you.
so much.
do you, sorry, do you have a-
Tabulation.
Tabulation.
So the
Collation
first.
sounds as if it would be cold.
I'm so sorry, I didn't hear what I
No, I'm sorry, I'm being facetious. I had collation sounds as if it should be cold, so I don't think it's the
Oh,
right
cool.
word to use.
Well, the first 3 pages cover statements made in witness statements, which are false during various proceedings. They've got page numbers and references to the supplementary bundle pagination, should you wish to look at them. I don't propose necessarily to take the court through them line by line, because in short, they are effectively trying to maintain compliance with District Judge Lew's order.
Do just before.
Yes, of course.
I've just received 2
Thank you.
attachments from Mr. Gold.
Oh,
I've only opened the first one, but I thought I'd show it to my
Oh.
ladyship and my lordship straight away.
We've just been shown an email which is presumably, which is dated yesterday at 9:36, which is from Mr. Staples, which says, "Please, would you advise the court?"
To
That was another rather pithy email from Mr. Staples yesterday morning,
Which is to Jash Gadhavi
who's in the Court
at
of Appeal.
justice.gov.uk. CC someone, I think it probably at your solicitors, Livingston.
Yes.
And it says, please would you advise the Court of Appeal that the respondent concedes the appeal?
Yes. The court will recall the discussion about the letter of the partial admission in relation to.
Yes.
On one view, that email has got even less information than the partial admission had in it. It gives us no indication as to why or what basis, or how it's put. We still, by this stage, don't have any fresh skeleton argument from my own friend about how the material served some 10 days previously, since deconstructed by Milena Jr., sent back by way of a supplementary schedule. We have no response to that at all. And so yesterday, I was faced, as the court will appreciate, with a number of questions from my lay client about what the respondent's position was in relation to all this. And we didn't hear anything until 5 to 5. And that's the note which you've just been emailed.
Well, I think this is a note or an email, but that you were referring to the note which conceded contempt in relation to paragraphs 2 and 3.
Yes.
And that sounds as if it's different, because that's just
So that's the second attachment to my first email, I think.
That's
Thank
the
you.
note. I just opened the other one first.
Thank you. So that is Mr. Gould's note that you were talking about. Thank you, Mr. Gould.
That's Mr. Gould's note.
Thank you very much.
I pause to observe that we have had literally nothing else from what I perceive shortly will be the admitted contender in this case, or anybody from the Northampton Police force about these events at all. That note is the extent of it. I was in the process of helping you with the schedule.
You were.
Can I just, what I would like to do, because it is relevant potentially to how this court deals with the matter in terms of consequentials, take you to what is in fact the 4th page. And the last entry box on that 4th page is in relation to Simon Staples.
Yes.
And does the court see, this is in a witness statement dated 15th of October 2025, reliable. So all the rest of the entries that you see over the next 3 pages are all statements of falsity, inaccurate, that have been made effectively to this court. Now, whilst no separate contempt proceedings in relation to that have been brought, this court will be aware that it has its own jurisdiction to issue its own contempt proceedings should they be indicated. And about that, I say no more for the moment. But it is, in our respectful submission, regrettable in the absolute extreme that even that material was supplied by Mr. Staples in witness statement form at no stage contained any vestige of apology, he being the author of statements which are included in my schedule. And as we sit here now, neither this court, nor the county court, nor perhaps even more importantly, my lay client has had an apology from anyone, still less the contemner, as we anticipate he will be, Chief Constable Northamptonshire, who I anticipate is neither in this courtroom or on the live link. And we are concerned about that, because by any measure, a concession that an individual is in truth in contempt of court, such as I anticipate will be made, is a very serious matter, particularly when it's so long in the tooth and continues to this day, both in relation to public trust and confidence in institutions such as the police force, and that's before I even get to, frankly, not only a contempt of court being committed against my lay client, but she has been treated with contempt. And our respectful submission is that that regrettably continues today. I think we started out talking about housekeeping, milady, but obviously we've drifted, and I hope I put some flesh on the bones, hopefully, helpfully where we are. It does seem to me now, permissions having been granted in the way you described, that we need to hear from the respondent about what is going on.
I think the best way forwards now, as you say, is that we hear from Mr. Gold, first in relation to the position on the applications, and then what his position is in relation to this appeal. And then I think it would be necessary after that to come back to you to see where you say we should go from here.
But it may well be, I don't know if you've had a chance to look at Mr. Gold's document.
Only just.
Well, it may well be that you should maybe take a few minutes to read that, so you're appraised of at least that document. I know not, it's entirely a matter for the court, but there we are,
The cavalry.
Aha.
as if by magic.
Thank you.
Now, can I assist you or the court in any other way?
No, I'm very grateful. Thank you. I think that what I should do now is, Mr. Gold, first of all, thank you for sending that through to us again. To go back to pure housekeeping matters, I indicated how I thought that the applications should be dealt with when Mr. Leonard was on his feet, and that was that in relation to the fresh evidence from Mr. Staples, that permission should be given to rely upon that. After all, the vast majority of all this further documentation is based upon it. I assume that therefore you don't have anything further to add in relation to that.
No, my lady, the application is conceded.
Okay. And then in relation to the further supplemental skeleton, which explains the most recent but not absolutely most recent wodge, if I can put it like that, of information and data. I was suggesting that it's obviously appropriate that permission to rely on that should be given. I assume that you have nothing to add in relation to that also.
No, nothing in relation to that, my lady.
And what do you say, if anything, in relation to the further amended grounds?
The respondent will concede the ground insofar as there's an application for permission by my learned friend to amend his grounds. No objection is taken.
Thank you. Okay, so we've cleared the decks in relation to all of that.
Yeah.
Now, if you would explain, Mr. Gold, precisely where we stand, I think perhaps before you do so, if you give us a few moments just to read your note, and then I'll come back to you. Mr. Gold, if you can just therefore explain to us where your client stands.
Yes. My lady, in due course, I have written instructions from the Chief Constable as to the specific statement that he would wish me to make after the conclusion of these submissions. But my lady, my lords, will no doubt consider it appropriate for me to set out the history in which this matter has come before you in this manner. The initial contempt hearing appointed Her Honour Judge Genn had been unsuccessful. Her Honour Judge Genn had found that it had been sensible for a witness statement to be provided by Miss Kiteley-Jones as a person who was more specialist, and had declined to find a breach of the order in that respect. However, in the supplemental bundle at page 250,
That's the first supplemental bundle.
first supplemental bundle, my lady.
That's the transcript, is that right?
Yes.
Sorry, could you give me the page number again?
250. Yes.
At page 250,
Mm-hmm.
Her Honour Judge Genn considered that there were two further matters that nevertheless ought to be addressed by Ms. Kiteley-Jones, notwithstanding her dismissal of the contempt application. And she had said that those were the searches that she performed and whether there were any master tapes. And so, in consequence of the judge's invitation, the further statement from Ms. Kiteley-Jones was obtained and appears at page 299 of the supplemental bundle. And at paragraph 2, Ms. Kiteley-Jones set out the matters that she had been asked to state, the nature of the searches, where footage had been identified.
Did you say 299?
299, my lord.
Mine aren't numbered.
My bundle stops at 295, but I have got documents after that behind tab.
I've got it behind tab 14.
Tab 14, yeah. Okay, thank you.
And it's a witness statement of the 12th of December 2024.
It is, yes.
Yeah. And the judgment, the transcript is the 11th of April 2024.
Yes, that was the transcript that followed judgment having been given. The transcript of the judgment is in the core bundle, and the further discussion that followed it is in the supplemental bundle.
Which included matters such as ordering costs against the appellant.
It did. It did. It
But
did.
we are looking at a substantial gap between the orders made by Her Honour Judge Genn and a witness statement in December.
Yes, I don't seek to suggest that it was timely or that it ought not to have been provided before, only for the purpose of demonstrating the matters that Ms. Jones had commented upon in circumstances where the respondent at that point had been successful in opposing the application for contempt. I appreciate that the reasons that I have said, that the respondent now seeks to concede that, in fact, there was contempt. But at that particular time, the respondent had had the information from Ms. Kitely-Jones. The judge had said in her further matters that there were 2 issues that ought to be provided and invited them to be provided. And the respondent obtained a further statement from Ms. Kitely-Jones that sought at paragraph 4 to describe the searches that she had performed.
Mr. Gold, I have read this statement, and I got as far as paragraph 38 on the basis my lady's pointed out. This is a December 24 statement in which
Yes.
Ms. Kitely-Jones says, paragraph 38, the 7 elements of footage already disclosed are all that survive.
Yes. And
So I'm not really sure how that either helps us or in fact takes the case any much further when within the last week it's plain that statement's wrong as well.
it is wrong, my lord. I simply seek to set out the manner in which the concessions have now been made and are being made to my lord. It's that after that statement had been provided and the respondent at least had understood from Ms. Kitely-Jones, who was considered to be one of the specialists in the force concerning this system, there was a further request or a further approach from the appellant's legal representatives to ask for, or if it were possible to obtain further detail as to the audit material. And insofar as it was considered that it was sensible to do so, because that could have allayed fear and suspicion, the Chief Constable performed a further audit.
You said twice now, I think, the respondent understood from Miss Kitely-Jones, or the respondent had information from Miss Kitely-Jones, as if Miss Kitely-Jones is not acting for the respondent when she's doing these exercises.
My lord, yes. I say that insofar as the those who instruct me and those who are more senior have a lower degree of expertise in these particular systems in their interrogation. And so the respondent had tasked her to perform the searches and then called her evidence before her on Judge Genn, had provided that, or the information that she had given to the appellant. That information, as one can see now, was wrong, and I don't seek to support it. I say only that at a point where the respondent had succeeded on the contempt application and had provided a further updating statement before the appeal in this matter was heard, the appellant's representatives sought what they considered to be further gaps in the audit, and the Chief Constable considered that it was appropriate to perform such further audit in order to allay grim suspicion in the expectation that it would demonstrate that there was no further material to provide. In the event that that was performed, and on these, and I appreciate the delay in which that was performed, whilst on the 2nd of October of this year, I was informed that the respondent had performed a further audit and had received 170 pages of data, the meaning of which was not immediately apparent, and so it was necessary for further information as to what the audit showed.
So we got another slippage of 10 months or so.
My lady, yes.
When you say the audit, the meaning wasn't clear to whom?
I had received 170 pages of data, and I required assistance to understand what the pages of that data was. And so I informed my learned friends that I was awaiting the explanation of a further computer audit that I had hoped the respondent would be able to provide. And I was unable to say at that point if it in any way answered the questions or the concerns that the appellant had asked. But that as I had understood it, it was intended to be comprehensive. There was nothing likely more that would be obtained. It was on the 7th of October that I had received the first results of an audit, which was over 1,000 pages. And again, I required some assistance to understand what the data meant and what it showed, and was concerned if there was further footage that had to be provided, given the large amount of material and data that I had sought to read, and or if there had been any body-worn video footage that had been uploaded and not retained, and how that would be shown. And so there was...
So in fact, you received the raw product of the audit, and you were doing the interrogation of it and asking your client to explain what you saw within the raw data might be inadequacies or routes that needed explaining.
I certainly require assistance to understand if there could be valid concerns that there may be material that had not been provided. And so there was a further conference with the Chief Constable where I was taken through parts of the data, an explanation as to part of what it showed, and that was required, that was considered important, sufficiently important to put into an explanatory statement. And so I then informed my learned friend that there may be further material for the respondent to provide, and that I had hoped that something substantive could be provided the following day. I had also been informed at that point that further footage had been found.
When was that?
On the 7th of October.
It was on the 7th you were told there was further footage.
Further footage. The footage from PC Rideout, which of course was a matter of concern. And a matter of concern is that if there was further material that had not been provided, that would have
particularly as PC Rideout's material had been identified just the 2.5 years before.
Oh, yes.
The claimant had expressly referred to that body video footage.
Oh, yes.
And is that what led to Staples 2?
There were some further steps, my lord, in that it had been hoped that the footage could have been provided to the appellant swiftly. It is not by way of excuse that I inform my lord that the force did not have the technical ability, the equipment or the subscriptions to be able to share or transfer footage of the size of those files. And so I had created an encrypted OneDrive folder so that the material could be sent to me to review and on which to advise. And in due course, later that day, I created a further OneDrive folder so that could be used to share the footage with the appellant's solicitors. It was later that day, on the 8th of October, that I had received a statement from Miss Kiteley-Jones that had reiterated some of the information in the statement of December 2024, which I had taken, my lord, explained the technical terms that had been used in the data in the audit, so that they could be more readily understood. It explained what were the results of that audit. I had therefore informed my learned friend the respondent was to serve an audit report of some 1,200 pages of material with an explanation and body-worn video that had been found during the audit. The material was sent, as I understand it, sorry, I had understood that it was to be sent the following day on the 9th of October, and a link to the material was sent at 14:54. The password was sent, I think, some half an hour later. By then, I had had the time to read further through the pages of the long computer audit and had noted that they had not referred to 2 police officers. Those are police officers who had been involved in the incident later the same day, not during the first arrest, but when the appellant was subsequently detained later that day under section 136 of the Mental Health Act. And so, in consequence, Ms. Kiteley-Jones was asked to search also for any potential footage or files in relation to them. I had received the following day, on the 10th of October, the further audit information or data relating to those 2 officers, although I had received it in one document rather than as a supplemental document. And you will have seen in my learned friend skeleton where he refers to the page numbers of the data changing. It was in consequence of the further search being performed and it being printed as one document rather than as a supplemental one.
So that's on the 10th.
It's on the 10th. In those circumstances, it was necessary to inform the Court of Appeal, at least, that further footage had been found in the course of a further audit. And in retrospect, that could have been done in correspondence, because the overwhelming likelihood was that the appellant would seek to amend her grounds to refer to the failure of the respondent to have provided this footage at the time in accordance with District Judge Young's order, and that incorrect evidence would have been given to Her Honour Judge Genn. As I had understood it from the information provided by Ms. Kiteley-Jones, the reason why the footage from PC Rideout had not been provided was because it had been saved under the wrong occurrence number. Every incident or criminal incident would have an occurrence number. And for video footage to be saved, it would have to be attached to an occurrence number, and within a short period of months, when the system was being changed over, it have to be manually saved. And she had said and explained in her explanation or her statement to the material that she had found the material by accident when searching and attempting to cross-reference any video footage that had been attached to the names of the officers, and so had found it without having expected to, and that had any search been performed on the occurrence numbers, as would typically be done to find not just video footage, but all manner of data related to an incident.
Well, it depends how carefully you're going to do it, doesn't it? If you're looking for video footage by Officer X on occurrence number 123456, you can search under occurrence number and or against Officer X, can't you?
Yes, well, that is...
She'd obviously done it under occurrence number.
Yes.
So saying she found it by accident, I think, is perhaps a little potentially misleading. She searched against the name, whereas before she just searched against the occurrence number.
Yes,
Yeah.
Forgive me, my lord. I don't seek myself to suggest that it was by accident. I say...
No, she said she'd found. I think your submission, which I wrote down quite carefully, was she said she'd found it by accident.
Yes,
Yes.
yes.
Well, I don't want to interrupt my friend unnecessarily, but this whole sufficiency of search issue is being given a degree of ventilation still in the respondent's position. Can I just ask you to look at one statement briefly, and Malone and Frank can deal with it. It's in the updated supplementary bundle, the first bundle, and it's either 163 red or 222 black. It's a statement from an officer by the name of James Nealon. You won't remember this, but he's the officer who spoke to the event very
Yes,
shortly
at the
after
beginning.
you do, thank you, after the incident, to say that he was watching footage of her being arrested. Picking up on my Lord Justice Fraser's question about searching, at paragraph 9 of his statement, as my Lord Justice Fraser has that, it's got a red page 165 on it.
Yep.
Black 224 on at this paragraph. And this is a police officer. It's not the person to whom I refers to as the expert. At paragraph 9, clearly when I was speaking with Miss Buzzard-Quashie, I could see the BWV I was referring to. To do this, I would have accessed the body-worn video at that time. I would have gone into the folder relating to each officer that I could identify. From there, I would then search for the footage, going from the date of the incident to check against the date that the footage has been uploaded. And so, if I might say so, that underscores with some vigour the point made by my Lord Justice Fraser about the search being undertaken and the nature of it, when even a police officer, not apparently an expert as has been described, could and would have found this without any difficulty at all some many moons ago. And we have an email also in the bundle from another individual describing what had happened, and that's at your red page 173, black page 232. This is an email from a lady by the name of Naomi Langhorne, sent as long ago as November 2023 to my own friend's instructing solicitor. And she describes her job as a crime case builder from the Criminal Justice Unit. And she says, does the court have it? I see that on the 14th of September 2021, I emailed officers Minchinson, Rideout and Neal to upload their BWB footage to Dems Nice for me to review before the 27th of September, as no footage was available to me on Dems Nice. PC Scivier confirmed they had no BWB. He'd gone out without a camera that day, it seems. And then this, on 14th September, PC Minchinson emailed back to say he'd uploaded his, PC Neal's, PC Rideout, and PC McKitten's BWB to Dems Nice. And so, as long ago as the 14th of September, the existence of Rideout's BWV was known of, unquestionably, by this individual. And in combination with what I've just read to you about PS Nealon's evidence about how he would go about the search, it was there to be found, and let there be no mistake about that.
Mr. Gold, you were saying, submitting that Miss Kitley-Jones had said that she had found it by
Yes.
accident, and that is what she had said, but that you were not necessarily saying that.
Molly, that's correct.
Yep.
And I don't dissent from what my learned friend has just said, that the footage was there to be found. In respect of Sergeant Nealon's statement, my understanding is that that was during the period of the first 31 days when the body-worn video, which the body-worn camera had been docked. The docking of the body-worn camera, Ms. Kitley-Jones explains that the video is automatically downloaded to a special folder called My Video and wiped from the body-worn video. In order to be retained after 31 days, that video must be attached to an occurrence number, otherwise it is automatically deleted. And so at the period to which this statement relates, I understand that the video had been uploaded and would have been in the My Video section, but that subsequently it had been attached to a different occurrence number. And so when a search on the occurrence number had been performed, the video hadn't shown. But I don't dissent from the other comments that my learned friend had made, that there is a statement saying, or at least email saying, that there had been material uploaded and that it hadn't been found. I think I had been, my lady, at the point where I had said that the respondent considered it was important, at least to inform the Court of Appeal, that further material had been found, because the likelihood was that the appellant would make an application to amend their grounds. In the event, my instructing solicitor had in fact applied to rely upon the material, but there was no purpose to assist the respondent in relying upon the material, where it had said in terms that body-worn footage had been found that hadn't previously been provided, that had been from PC Rideout. In consequence of that material having been provided, the appellant did apply to amend their grounds of appeal, and my lady, my lords, had the application. And in the course of that application and in the skeleton, it had made clear that there was concern as to further material, in particular that it had failed to show the dates of deletion of material, and that there were multiple file numbers for officers in respect to video that had not been provided. And so further instruction was given to Ms. Kitely-Jones to ascertain what further information concerning deletion of videos could be obtained. And I attended a remote conference in order to watch Ms. Kitely-Jones self-interrogate the computer system. And in the course of the interrogation of the computer system, where I had asked for specific files or file names to be searched for, what was produced was a video, the PC Virtue 2, that was said to have been either deleted or not to be available, or in any event had not been provided. And so at that moment, when PC Kitely-Jones had retrieved...
And not PC, she's not a PC, is she?
Sorry, did I say, forgive me.
No, no.
When Ms. Kitely-Jones had retrieved a video from PC Virtue that had not been provided, it was immediately clear that this was material that ought to have been found by a search on the occurrence number.
What day was that, your remote conference?
The 20th, my lord.
So that's Monday of this week.
In the evening.
Very much.
And in consequence of there being at least one video file that ought to have been found on the search of an occurrence number that had not been produced, I and my instructing solicitor were concerned that there may be the potential for further such files that could be found, and that a further interrogation needs to be performed, but also that Her Honour Judge Genn, or rather the respondent, had called evidence before Her Honour Judge Genn to the extent that all video footage that could have been found with a reasonable and proportionate search had been, which was incorrect. And therefore, that the content of the statement of Ms. Kitely-Jones and the solicitor, Mr. Staples, that had been adduced before Her Honour Judge Genn was similarly incorrect in consequence. And so in those circumstances, the matter being of exceptional seriousness, information being provided to a judge in contempt proceedings that was incorrect or potentially incorrect, it was necessary to seek instructions from either the Deputy Chief Constable or the Chief Constable as to the concessions that would need to be made in this court, and to have those instructions signed by the Deputy or the Chief Constable. In the meantime, the following morning, the matter was put, or rather the Deputy Head of Legal Services sought to take instructions from the Deputy Chief Constable or the Chief Constable. In the meantime, my instructing solicitor, who was to enter meetings that morning, sought to inform the court that the appeal would be conceded, hence the brief and terse email to which my lady and my lords have been taken.
And that's yesterday.
So it was yesterday,
So you have your remote conference Monday
Monday evening.
This all happens yesterday. That explains the email to the Court of Appeal yesterday.
I was at around 10 to 5, I received signed instructions from the Chief Constable, and the respondent's note was filed with the court. And that note states the concession that this concession that my lord has, my lady has before you, and the matters that is necessary for me to concede now. And so in those circumstances, there is no proper basis upon which the Chief Constable would continue to resist the appeal in circumstances where there was further footage to be provided. And even although I appreciate that my lady and my lords may not seek to deal with the footage or view the footage in respect of a PC ride-out benevolently insofar as it hadn't been produced. But in respect of the PC virtue video that ought to have been capable of being found on the search for an occurrence number, where the judge had been told that searches of that nature had been performed and that there was no further material and that there potentially was, that matter meant that the response position was unsustainable as it had been put in the skeleton and in its resistance to the appeal, and that had Honourable Judge Genn been aware of that, it is likely she would have reached a different decision on the application. My own friends have said that respondent has failed to apologise to the appellant. The Chief Constable has failed to apologise. And prior to today, and again, I don't seek to say this by way of mitigation, but by way of explanation, there have been a number of apologies that have been made by the Chief Constable for the failures in the manner in which the matter has been handled. There was apology expressed in the skeleton argument for this appeal that had been filed earlier this year on my part. There had been apology expressed by Chief Superintendent Hillary, who had sought to adopt or rely upon the information provided by Ms. Jones, and apologising for the deletion of footage that had been thought was no longer available and that ought nevertheless to have been retained. There is a further statement. I have instructions to make a further statement in respect of apology and further matters from the Chief Constable. It may be that now is not the point at which my lady would wish me to make those submissions, but I have a further statement on behalf of the Chief Constable to make.
Well, let's just go back one step to the witness statement of, I can't remember the rank of Mr. Hillary, Chief Superintendent, I think.
Chief Superintendent.
That was a witness statement for which permission was not granted.
Yes.
And then there has been correspondence, I think, between you
Yes.
about the apology element within that statement,
Yes.
which you still seek to rely upon. and you've mentioned to me now, and I think that the position is, Mr. Leonard's position is that he doesn't dispute that factually the witness statement contained an apology, but goes no further than that. I think he'll explain, before we go on to the next stage, I think he'll explain that to me.
The position that you really correctly summarised the position, it's in our supplementary skeleton argument. And the key point to bear in mind is that the time, whatever that apology is taken to mean, is given, we know nothing about the fact that there is still missing footage that hasn't been disclosed. And so it's an apology of sorts, but not on the factual basis that we are now working within by any stretch of the imagination. And so, if my own friend will forgive me, it's cold comfort would be giving it a status it probably doesn't deserve.
I was to say, before my learned friend interjected, notwithstanding the Chief Superintendent had expressed an apology, it is in fact an apology on a factual basis that is incorrect and that does not exist. And so the appellant could have felt that, notwithstanding that an apology had been made by the Chief Superintendent, that she may draw little comfort from it in light of the matters that have subsequently transpired. And I therefore have separate instructions to make a separate statement and to express other apology and other matters in relation to it. But that is...
and that's where we were, and that was where you had come to, and I think that you should proceed with that now.
May I make it clear before anything happens? I haven't seen anything of what is about to be said. My learned friend speaks to a statement. I don't know if it's a written statement he's going to read out, in which case, theoretically, I suppose at least some sort of permission ought to be granted for him to rely on it. And as I say, as I haven't seen it, I can make no submission about it, save that it is surprising indeed that if that was a document to be relied on before this court, that the appellant wasn't given the chance to consider it in advance. Otherwise, I leave it in the court's hands.
Yes, Mr. Leonard, but let's hear from Mr. Gold how this statement comes about, its date, its provenance, and its content.
Yes, it is delivered by me in the course of my submissions, and I had received written instructions to make it yesterday. I had said that I had asked for written instructions in relation to this matter and had received those yesterday at, I think I had said the time was just around 10 to 5 or so.
And this is from the Chief Constable, did you say?
From the Chief Constable.
And this is a document, well, I don't know, I don't want to put words in your mouth. This is something crafted by you and approved by him, or?
I have no documents that I'm able to provide in an appropriate form at present, namely a signed witness statement with a statement of truth from the Chief Constable and a wet signature. But in the circumstances of the concession, Court of Appeal would no doubt want to know the steps the Chief Constable is taking in relation to these matters, and to hear the Chief Constable, through his counsel, express his apology in respect of what has happened. And if not the court, then of course the appellant may nevertheless wish to hear it stated in public, the apology that the Chief Constable has instructed me to make.
You go ahead.
The Chief Constable says that first and foremost, he apologises to the appellant, Ms. Buzzard-Quashie. He apologises to the Court of Appeal, and he apologises to the County Court. The County Court had ordered him to provide Ms. Buzzard-Quashie with all copies of body worn or other video footage in connection with her involvement with police officers on the 3rd of September 2021. There has been, the Chief Constable accepts and admits, serious failure in the force's compliance with that order, which he does not understate. Not all the body-worn video files that had been uploaded and saved to the digital evidence management system have in fact been provided. Further, the specialist evidence or witness evidence from the False Data Protection Unit presented in the county court and to this court wrongly said that it had been. And whilst there may have been some footage that had been saved to a different criminal case, there has at least been footage that was correctly attributed and which has not been provided. The Chief Constable appreciates that this court will have the greatest concern that it was possible for this not to have become clear until a very late stage, and indeed the day before the appeal. And worse still, there may be justifiable concern that in fact it might not have been clear until after the appeal had concluded. The forces compliant with court orders and the accuracy of the evidence that it presents in court is a matter that goes to the heart of public confidence in the police. He has now instructed the Data Protection Unit to provide, in accordance with the request of the claimant's legal representatives, a list of every body-worn footage file created by every officer who was involved with Ms. Buzzard-Quashie, and the dates and times on which each of those files was created, accessed, transferred to the evidence management system if it was, or deleted. He has referred this matter to the Force's Professional Standards Department, which is the department of every police force. It is responsible for investigating breaches of the police staff or the police officer standards of professional conduct, and has told them to refer the matter to the Independent Office of Police Conduct. He himself will inform the Police and Crime Commissioner of this matter and of this concession. The Chief Constable accepts that that is, of course, separate to any further action that the Court of Appeal or the County Court may consider it necessary to take, but that he instructs me to make this statement in open court. I'm instructed to repeat his appreciation of the grave seriousness of this matter. He repeats his apology, and there will be an investigation either by the IOPC, or if not, if it's returned to the Force's Professional Standards Department, into how this has happened. At the moment, my lady, subject to further questions that my lady or my lord may have, that's the submissions that I'm instructed to make to this court, and the apology to Ms. Buzzard-Quashie.
Thank you.
I do just have one point, and I'm sure I know the answer. Concession is a word that has different meanings. I'm interpreting the word concession as an acknowledgement or an acceptance that you cannot contest the appeal.
My lord, yes.
Is that correct?
Yes.
Thank you very much indeed, Mr. Gold. I think it's appropriate now that we rise for a few minutes. Please take it away. We'll be about 10 minutes.
All rise, people.
You're explaining everything very well.
Well, I have read it.
I'm Maria. Nice to meet you.
Very
Hey, how you doing? I knew it was bad when you were telling me to stop. You have to go outside. Wait outside.
We're still slightly getting our sort of getting something to grab with the judiciary. Where do you practice that? Absolutely. Watching it. Watched them before. Good, interesting.
Sorry, what was that? Another 10 minutes, you say?
No, so it's almost up the time.
Oh, right. Always get back in. Oh, I see.
Have you got one, Jane? Is that?
Yeah, they don't need to read it in advance. He'll speak and take the turn. Yeah. There's nothing you need to read in advance. I have to admit, when we're waiting for the judges, I always stay standing because it would. So it says to me, if you think that, just steps in you by jumping up and down constantly.
Great.
No, I'm very much person. Very much enthusiastic about society. It's just what's it called? It's the all sport about the efficient expenditure of energy.
Is the call ready? court rise if able.
Well, of course, inevitably, given how things have transpired this morning, the appeal will be allowed. There are some issues which remain outstanding. The first of which deals with and goes to Mr. Gould's statement to the court, and I think that it would be appropriate were that to be in written form also provided to us, and of course provided to Mr. Leonard and his clients. We think also that in fact there ought to be a witness statement by the Chief Constable, which includes the nature and extent of his apology, but also sets out how all of this came about in a way in which we can all follow and understand in one place. Including very helpful explanation that you have given this morning on your feet, Mr. Gould, so that that's all together in a witness statement. Obviously, there are other issues which remain outstanding. You've conceded this appeal on the facts, on the circumstances, but there were legal issues at large, and they remain to be determined. Are you and Mr. Leonard content to rely upon your written submissions in relation to, and I'm thinking of the position of a Chief Constable in relation to contempt of this kind, the question of whether a penal notice was necessary, and the issue of the nature of the intent which is necessary for contempt of court in circumstances such as these? I'm thinking of those legal issues. Are you content, both of you, to rely on what is in your written submissions?
My lady, yes.
You are.
Well, I say yes. I don't wish that sounds equivocal. There were a handful of further pages in the transcript following the judgment being given, to which I would have referred the court. But I wouldn't seek to go beyond that, and I can provide those to the court either orally or by way of a short note of 2 or 3 lines, which I can copy to my learned friend.
I think that a short note would be very helpful, thank you, but please, of course, send it also to Mr. Leonard. Mr. Leonard, you might need to respond to those few lines, and so I should have said, first of all, if you can provide that note, which you suggest is very short, if it's possible to provide it perhaps by 4 p.m. tomorrow. Is that possible?
My lady, yes.
Yes, and that then, if necessary, if there's anything to respond to, also in short order,
Yes.
that you do so by the end of Friday, by 4 p.m. on Friday.
I'm sure that's possible.
Because I don't think that this is hopefully an enormous issue, but just giving you the opportunity to respond.
Yes.
And then, Mr. Leonard, are you content with what is in your skeleton in relation to those legal issues?
The legal issues have been set out clearly in our submission.
Okay.
But it's slightly more than that, though, in my submission, and that is going back to the email sent by my own friend's instructing solicitor, as I've put in the note of the 21st of October. That is a concession. The purposes of this action alone, setting that aside, the Chief Constable of Northamptonshire is prepared to admit contempt. And so, therefore, by that admission, we would say the vast majority of the legal issues that have been raised in any form are swept away. And moreover, as a consequence of the way in which this hearing has unfolded and the way in which my own friend puts it, then this appellant is entitled to this court making a declaration that the Chief Constable is indeed in contempt of court in relation to paragraphs 2 and 3 of District Judge Leung's order. That seems to be beyond peradventure.
I think you were about to be asked by her ladyship. I
Yes.
don't think she'd finished.
No, I hadn't.
Oh, so sorry.
No, I was just, I can quite see what you say about the admission, but you're content otherwise. There's nothing further that you would want to say about those legal issues.
I don't believe so, subject to what my own friend says.
Absolutely. And then there are 2 further issues which
Yes,
arise.
forgive me.
The first of which is the sanction which should be imposed, which is bringing us on to what you were saying about declaration or other submissions, and also the cost situation. So if I could invite Mr. Leonard to address us in relation to appropriate sanction, and then we'll move on to costs.
Well, those are bound up with one other issue of significance, and that's what happens after today in relation to the failings that are extant. In other words, my own friend has not come before the court today and said, there we are, that really is it. He's come before the court today and said there may yet be more. And the court will recall, when I opened this appeal, that there was a sense in which we couldn't say as we stand here now how bad it is, because we don't yet know just how much footage has not been disclosed. And so I'm afraid our position as we stand here now is that submissions on sanction can only follow the material which you are going to be provided with by my own friend in due course. And I hope that's recognises that the changing landscape that we're dealing with and have been dealing with over the last few days.
So you would, first of all, wish us to make an order that all further material be provided by a specific date.
Yes, and alongside that, of course, if now that the appeal has been granted, the question of where it now goes and who, as it were, polices any order made by this court, and we for our part, and we can make submissions about that, would be extremely concerned about this being sent back to the county court, as it were, as a piece of unfinished business, and we would seek this court's regulation, if that's not the wrong word, of any order that follows in relation to disclosure, with liberty to apply in relation to that, potentially to a single Lord Justice or Lady Justice, as the case may be. Now, we haven't formulated a draft order in that regard because, as I say, matters have been moving pretty quickly, and quite where we were going to end up today was not immediately apparent. So I hope that's helpful to the court, but it does, of course, involve further steps being taken before we can get to the point at which the court would want me to address them on sanctions. Hitherto, there's an argument for saying that all my lay client has ever wanted is the material that she was entitled to, but it seems to us, on one view, the way matters have unfolded relatively recently, make this a significantly more serious position than we ever thought it was. And to understand the breadth of that is what the court should next do in our submission before deciding what that sanction for contempt should be. And we also, as I say, have a potential consequentials submission to make, depending on what, again, arises out of the exercise that my lady is going to order my own friend, lay client, to deal with today.
Okay, so you are seeking, in addition to the requirement of a witness statement, a written version of what Mr. Gold said today, and a witness statement from the Chief Constable containing that apology and an explanation of everything that has gone before in a way that fits all the pieces of the jigsaw together. You also would seek an order from us that all further material be disclosed by a specific time, with an explanatory witness statement in relation to that further material.
We would say that the orders of District Judge Leung 2 and 3 are still outstanding in terms of compliance, and but that there's if you just give me 1 minute, but there's a sense in which we can only know what the consequential order needs to be.
But that's what you're seeking right now.
Absolutely.
If you want it policed by us, we've got to make an order.
Well,
Yeah.
I feel the sentiment in my lord's question, but
Well-
the difficulty is
Well, I mean, I completely understand, speaking
yes
for
is the
myself,
short
why
answer.
you've asked for that, but we can't police things with that aren't by reference to our own order.
precisely so, which is why we require an order in relation to.
So the answer to my lady's question, I think, is yes, that you want an order that all further material be disclosed by a certain time with an explanation in relation to that further material.
We seek a mirror of District Judge Lung's order that had been made from this court in the light of what's been.
Well, it might be a bit more sophisticated than his.
Well, there's always a chance. my
It
lord.
reflects that it will reflect the fact that it has been District Judge Lung's order is simply a blanket order about all material. There's been quite a lot of water under the bridge since then.
Understood.
And as my lady's already identified, the position up to and including today is going to be explained in the witness statements that
Yes.
Mr. Coulson been told about. Future material, which it appears may exist but has not yet been produced, you're going to have a date for that to be produced and an explanation of why it was not included in the material before today.
Precisely,
It's
and that-
going to need to be more complex than
I do understand that. What I was trying to say is that essentially what District Judge Lung was after, we need again today, with a as it were a finesse on matters as it happens. So I entirely agree. Would the court give me 1 minute to turn my back?
Just think about dates. What do you do? Yeah. Timing. Sorry about that. You were taking instructions and we were using the lull.
Lady, a couple of things. I mean, there are a number of points that my own friend made that in the ordinary course of events I would like to come back on, but in view of the fact that there is potentially going to be an exchange of information between us to assist the court over the next 48 hours, I'd be content to, in short order, confine, as it were, those reply points to that document, if I may. My lay client is very keen that if the court feels that it has enough information today and now to deliver a sanction on the findings of the contempt as has been raised, then so be it. It will have to make therefore an assessment of whether it needs to see the new material or not, and that will come in any event, sanction or no sanction. But in view of the way I've drawn the court's attention to what has happened in this court, you may feel, as from a public interest perspective, that we need to wait and see what else there is. But I leave that in the court's hands. But obviously, being faithful to my lay client's instructions, I draw that to your attention. And if I may, one final thing. My lay friends referred to instructions from the Chief Constable. I have here in front of me, at my invitation, some instructions from my lay client about the impact of all this on her. Now, I can read it out to the court, or I can attach it to a written document for the court to be aware of, bearing in mind the history of this matter, if I might say so, and her persistence in getting what she wanted. and has now got it. It would
And
be,
the huge delay.
and the huge delay.
Thank you. Let's take this step by step.
Isn't
I'm
it?
very grateful for your suggestion that you will make other points in response to the few lines we were told that Mr. Gold is going to put together and have with you and with us by 4 p.m. tomorrow. You're going to respond to that by 4 p.m. on Friday, and that's the document in which you are going to add any additional points that you would have raised now. So that's one thing. The next thing is in relation to how this has all affected your client. I would be grateful if that were in writing also
Of course.
and appended to that document. That is not in any way to seek to limit it or not to give it proper space and air. And I appreciate that it's dealing with it in a different way from allowing Mr. Gold to read out what he'd been told and instructed to read out by the Chief Constable. It will be given its proper place and its proper weight. It's just that it's very important also in the same way as it is for the Chief Constable to put in writing what it is he actually says, that we appreciate and have an opportunity on paper to appreciate precisely what is being said. So I just want your client to be absolutely clear that it is not because we do not take it seriously. It's quite the reverse. It's because we do take it seriously that we would prefer to receive that in writing.
A solution I cannot improve upon.
And so that deals with those loose ends, I hope. I haven't. Let's go back. I haven't given a time at which the evidence of the Chief Constable should be provided, and I think it should be provided that witness statement, which contains a written version of the apology, but also explains up till now, puts all those pieces of the jigsaw together so we understand what has happened in relation to all of the different pieces of evidence and how they've come to light. That document, that witness statement, I think 14 days from today is appropriate for that. We're then looking forwards, as we've said before, in relation to what is outstanding, which it appears there are, or maybe matters outstanding. So all further data which exists must be disclosed also within 14 days of today, and also must be accompanied by a witness statement of an officer who is at least of the status of an inspector, explaining the data and what it shows and how it has been obtained, and also why it has not been obtained before. And that also, I think, can be achieved and should be all carried out within 14 days of today. So I think those are the practical matters that were outstanding. Of course, we have said that we will allow this appeal. We will give our reasons in writing at a later date, and therefore otherwise, to that extent, judgment is reserved, and that will be, for the most part, in relation to the legal issues that we have discussed. In relation to sanction, we also consider that it's not appropriate, despite the fact I can quite understand that your lay client would in some ways prefer to, after such a long time, have this matter put to bed. Nevertheless, given the seriousness of this and the way in which it has continued to unfold over time, I think it is very important for this court to have a full picture before it decides on the sanction to be imposed in relation to this very serious and considerable contempt. And so we will reserve our position in relation to sanction, and it will be necessary, it seems to me, that for there to be a further short hearing once we've had the further documentation and the further explanations.
Indeed, and it would, I suppose, at that stage, draft orders as to any consequentials would also be considered. What it may help, I don't know, at the court, if we were to supply a potential draft order with our submissions on Friday, so at least the court could see the nature of the direction in which we're travelling. If it wouldn't be of assistance, then we'll leave it. But we've got something in embryonic form, if I can put it that way.
That would be helpful, thank
So
you.
we'll do.
And then we'll have to make directions about a short further hearing, and also, if necessary, directions about further exchange of evidence, although I hope that won't be necessary, and of course lodging of skeletons. But I don't mean to make a mountain. I'm not saying out of a molehill, because this is not in any way a molehill, but I don't want to create further barriers and difficulties, particularly also because you are acting pro bono. But it is important that this matter is dealt with properly and thoroughly, given its considerable seriousness and importance. And so that is why I think it's necessary that we have a further short hearing.
We agree, but may I ask for one further, as it were, order from the court today, and that is the respondent knows it's got virtue in its hand as an undisclosed piece of footage. There is no reason why that cannot be disclosed forthwith, or at least by close of play, tomorrow afternoon, and that is an order I asked my own client to make. Okay.
Mr. Gold, there would be no difficulty in that by 4 p.m. tomorrow, would there?
I appreciate, my lady, that I stand not on the firmest foundations, but may I make at least some submissions in relation to the consequential orders that my lady is handing down?
But, yes, but let's just deal with that strand before we lose it.
Yeah.
The virtue materials.
Yeah. I heard suggested to my learned friends that some of the footage that has been provided does not, I'm told, contain the date stamps that the appellant had requested. And at this moment, I'm sorry not to be in a position to inform the court as to whether there are further files to be provided. The task that has to be performed is for someone to produce a list of all of the files that have been created, and then to search whether there is an extant file in relation to each of them. And my lady may consider that, insofar as there may be further videos that are provided, and insofar as the 7 that have already been provided will be re-downloaded with the date stamps, that it is preferable for all the material to be provided together in one tranche than for there to be videos sent or footage sent or files sent on different days, where a tally then needs to be kept or a record as to what was sent on what day, rather than for everything to be sent in its totality with a list of all the files, the dates on which files have or haven't been deleted in one document and in one instance.
So the result of that submission is you want that effectively that would be covered by the 14 days from today,
My lord, yes.
rather than 4 p.m. tomorrow.
My lord, yes. If it's to be ordered to be provided, the PC virtue video is ordered to be provided, then of course the Chief Constable will provide it.
But you could send virtue to tomorrow and still do your comprehensive catalogue, couldn't you, in 14 days?
My lord, yes. It would.
I dare say, I'm not speaking for the appellant or for Mr. Leonard, but I imagine they'd rather have it twice, the second time in the comprehensive catalogue, and have to wait 2 weeks to see what it shows them. But I don't know, I'm musing.
My musing was in the same form, and so I think that it's most appropriate, given the history of this matter and the enormous delay, that in fact what you've got and that you've identified in relation to Officer Virtue should be sent over, disclosed by 4 p.m. tomorrow.
Yeah.
The fact that it will actually form part of a comprehensive further disclosure and will have its proper date stamp on it and all the rest of it in 14 days' time will only add to a little reassurance on the part of the appellant, but I think she's entitled to receive what you have in your hand as soon as she can.
Really, yes.
And as an observation, Mr. Gold, because I appreciate that you've actually grappled with this matter in a far more thorough and conscientious way than appeared to have happened before relatively recently. I suppose, you know, whatever's happened over the last 2 years, at least as a result of your explanation to us earlier this morning, some intelligent application has been brought to the production of this material. But your suggestion of a comprehensive log and supplying it within the 14 days everything, properly date stamped, etc., is a very sensible one.
My lord, if I may, it is a request that had already been made by the appellant's lawyers, and so I ought not to, notwithstanding my lord's words, take the benefit of the suggestion that had been made by my learned friend and the appellant's representatives.
Well, the appellant's made a number of extremely sensible and proportionate requests over a period of a long time, hasn't she?
My lord, yes. The second issue
Yes.
is in relation to whether this court deals with the issue of sanction, or whether this court substitutes the order or the decision of the county court below, the county court then to deal with further matters relating potentially to sanction, where the county court has the same powers of the High Court in doing so. Could I ask at least that Chief Constable be permitted to make written submissions as to whether it is appropriate for the matter to return to the county court or for the matter to remain here in this court?
Can you not make submissions about that now?
Well, I would do if my lord wishes to hear them now. It may be that I can make those submissions now, my lord.
I'd be grateful if you would then.
The powers of this court in respect of an appeal under 52.213 will be to allow this court, will be to allow the appeal where the decision below was unjust because of a serious procedural or other irregularity, which will be the matters that have been ventilated thus far. The court would have the power, subject to any provision in CPR 81, to set aside the county court's order or to vary it, or if there were concern as to the factual basis upon which there may need to be sentence or sanction, to refer that matter back to the county court for finding before either that court or this court took that case, retrieved it to make its determinations as to sanction if that were considered to flow from it. So the court could either refer the issue as to the extent of the failure and the breach back to the county court for separate determination, or alternatively, it can seek to determine the matter itself. But in my submission, where even as the contender, Chief Constable would be entitled not only potentially to have evidence called further on the issue of sanction, but potentially also seek to have his right of appeal against such a decision preserved. If that matter were dealt with by the Court of Appeal, mean that the right of appeal would be to the Supreme Court, whereas the county court has the power to deal with any contempt in the same manner as the High Court would, and any appeal from that would return back to this court. And so,
When you say evidence on the issue of sanction, what do you have in mind?
well, it may be that upon further advice that the Chief Constable does seek to provide further evidence or further submissions on the issue of what the appropriate sanction ought to be. If there
This
is
is a contempt appeal. If the appeal had been successful, leave aside all the excitements of the last few days, if the appeal had been successful, then questions of sanction would have arisen. So there must be a position on sanction.
if the court had left the factual findings of the court below undisturbed, then there would be no difficulty for the court to proceed on the basis of those factual findings.
But Mr. Gold, you opened this by saying you concentrate on the words in 5221(3)(b), unjust due to procedural irregularity. There's also 5221(3)(a),
Yes.
which is wrong, and it might be that, in fact, notwithstanding your effective acknowledgement on the facts that you couldn't contest the appeal, that the judge below was wrong on the law as well.
Yes.
So if that's the case, when the written reasons come out, everyone will find out if it is or not.
Yes.
And as my lordships observed, sanction would arise anyway, because the finding of the appeal would be that the Chief Constable was in contempt as at the date of the hearing in front of Her Honour Judge Glenn.
My Lord, yes, it would do that by substituting the provisions of the County Court's order. And by substituting the provisions of the County Court's order, the matter would return to the County Court to proceed with those matters further and consequent upon the amendment of its
What
order
about
by
the
this
contempt to
court.
us?
My Lord,
What about the contempt to us?
if there are to be separate contempt proceedings, then those would be separately particularised.
This case has taken far too long and wasted far too much time, effort and money for that. I'm extremely surprised that your instructions appear to be to put this off again. Sorry to put it bluntly.
My Lord, it's only to ask for the Chief Constable to have the opportunity to put in written submissions. as to the
We're
appropriate
asking for your
disposal.
oral submissions.
Well, in my submission,
What
if they-
about a term of immediate imprisonment then? Should we go through the various options?
if there were that prospect, my Lord, I would require this court, I would invite this court to adjourn so that further or proper instructions could be taken, or if there were the
So
prospect
you're not
of-
prepared to make any submissions on sanctions?
well, if there were the prospect of the Chief Constable's committal.
Well, obviously, we're talking about contempt of court, so that's a possibility.
Then I anticipate that the Chief Constable may consider that he requires more senior counsel to address this court than I.
Well, I suppose one solution is when you get our written reasons on the substantive issues in what the appeal raised before your opposition to it was abandoned. The relevant pieces of information under 81.4.2, and I'm looking at H onwards, a brief summary of the facts alleged to constitute the contempt. So far as the contempt before this court is concerned, they'll be included in the written reasons, because obviously there was the opposition to the application for permission and the other material that was lodged prior to the developments of the last few days. And then at that point, we're going to have another hearing anyway. You can take a view, well, you together with the Chief Constable can take a view on what, if anything, you want to put in by way of evidence.
Yes.
To deal with the contempt in front of this court, as well as the contempt which de jure exists as of now, with the appeal being allowed in front of the county court.
If I understand, my Lord, it's that there will be the possibility then, at least at that point, of the Chief Constable making further submissions as
Yes.
to the manner
Well,
in
that
which
would
it
be
will
only
done.
fair, wouldn't it? On
And
a proper reading of 81.4.2, if we're going to deal with contempt in front of this court, the summary of the facts alleged to constitute that contempt have to be notified to the contemnor, and
yes.
that will come in the written judgment of the court on the substantive issues, on what the appeal, on the effectively today's appeal hearing. And then if that's going to be separately dealt with
Yes.
by this court in terms of a sanction other than or additional to any sanction that we might be considering in relation to what happened in front of the county court, well, that's the occasion to deal with it, isn't it? We don't send that back to the county court, do we?
No, my Lord, it's that if there is to be contempt in these proceedings, or the court is considering contempt in respect of these proceedings as opposed to the matter of the county court, the particular matters that may constitute the findings of contempt would be something that the Chief Constable would seek to make submissions upon.
Understood, and he'd be entitled to do that once he knows what the facts in summary are that would found that contempt.
My Lord, yes, but at the present time, the respondent has conceded the appeal and the judgment is to be reserved. If there are to be further and separate contempt proceedings, or a separate hearing for contempt, that would be a separate matter where the Chief Constable would be entitled to the requisite notice stating what the application was or the matters that would arise, and then to instruct counsel to attend that hearing.
I thought we were debating whether it goes back to the county court or stays here and appears where it cross purposes. You're right. If there's to be separate contempt application or proceedings in front of the Court of Appeal for contempt of court before the Court of Appeal, rather than what happened in front of the county court, he is entitled to notice, including, as I've said now at least twice, a brief summary of the facts alleged to constitute the contempt.
Yes.
In the unusual circumstances of this case, though, that brief summary of the facts will be included in our written judgment, and at that point he'd then have the ability, wouldn't he, together with you giving him advice, to go through the other provisions of 81.4 to make any applications either to lodge evidence or anything of that nature in order for us to arrive at a sanction if we are minded to impose one. I misunderstood your submissions at the beginning. I understood you to be saying that everything to do with sanctions should go back to the county court. Now, if I've misunderstood, I'm sorry.
My submission had been that in respect of the breach of the county court's order, that the matter could be referred back to the county court for it to address any sanction in respect of its own contempt of its own orders, and it would then have the powers of the High Court to deal with the Chief Constable in the same way that if he had committed contempt before the High Court. Insofar as the county court itself may consider that it ought to either seek to enforce its own orders or to deal with matters of contempt in respect to its own orders.
Well, it can't be right that there would need to be two separate contempt proceedings on foot at the same time if a contemnor in front of the county court opposes an appeal in the Court of Appeal, but is then found wrongly to have opposed it in these circumstances, such that they're also in contempt of the Court of Appeal. I haven't done sufficient detailed reading on that particular niche point, but I think what you're saying is we might have our own powers to deal with contempt in front of this court, but those can only proceed in parallel with the county court having the matter sent back to them because the appeal's been allowed as well. Is that the essence of what your submission is, that there should be two separate sets?
My Lord, no. It was that if the conduct of the Chief Constable were to be considered to be addressed solely in respect of the county court order below, then I would have invited the matter to return back to the county court. This court is itself considering proceedings for contempt against the Chief Constable separate to those that the county court would seek to address or deal with.
I understand.
Then of course that would be different.
And so you're saying in those circumstances, it's appropriate that it all should be dealt with by us, despite the fact that earlier you said that one of the issues would be the route of appeal, were we to impose sanction in relation to the county court.
That would, in my submission, be a reason for the contempt to be addressed solely in respect of the county court's order,
and not in relation to anything before us at all.
and not the matters before my lady. But if that's considered to be unattractive insofar as the Chief Constable's conduct in respect of this appeal ought to fall to be considered by way of contempt or sanction, then of course the matters could remain here insofar as the court has the power under the Administration of Justice Act to make any other order as is just.
Thank you. Thank you, and I don't think we need to ask for Mr. Leonard's submissions. It seems to me that it is most appropriate that all of the issues in relation to sanction, both arising out of the breach of the district judge's order and the contempt before Her Honour Judge Genn, and as it has also subsequently evolved before us, should be dealt with together. That is obviously appropriate and proportionate in every respect. I appreciate that that means that the route of appeal might be different, but it would be, in the light of the history of this case, grotesque, I think, if there were to be two separate considerations of this issue of contempt and of sanction. And so I think that it all has to be dealt with together, that to the extent that there is further contempt before this court, the notice and facts, as my Lord Justice Fraser said, will be contained in the written judgment of this court, and so that will be clear at that point. And if it's necessary to make further applications on behalf of the Chief Constable to lodge further evidence and the like, then that can be done at that stage. And that this matter, unfortunately in the sense that it adds to the delay and the cost, but not unfortunately because it is necessary, we'll have to come back before this court when we have the further evidence and the further material that we've already ordered. And it should hopefully be a short hearing, which will be no more than 2 hours when it comes back. And that it ought to come back in short order, that this shouldn't go cold and we shouldn't find that many months pass yet again.
We agree. Thank you very much. Much obliged.
Oh, and my Lord Justice Fraser has also said, are we in a position to deal with costs?
As a matter of costs in principle, obviously the order in the county court will be vacated come what may. As you've already observed, my own friend and I, and indeed our instructing solicitors, have done this entire appeal pro bono, and so there will be an application for a pro bono costs order in relation to the usual charity, which we will put in our draft order for you. It'll come over on Friday.
Thank you very much. I think that will do for now. Not quite.
Oh, and there is also a sum in relation to my late client's own costs in relation to when she's been acting as a
which is litigant in person.
Yes,
absolutely.
Indeed. Sorry, I did know that. I have been told. I've forgotten.
And that is generally, unless extra is proved on a particular scale.
Indeed.
Yes.
I'm just going to say that we are sitting together on the 17th.
Yes, we are.
I do have the Privy Council Monday, busy on the Tuesday, and we're sitting on Wednesday, but there is the Thursday, fresh one for Friday of that. So that might be, we shouldn't say anything.
We are anxious that this matter should not go cold and there shouldn't be a great deal of further delay. And my Lord Justice Coulson was just reminding me, when we are next sitting together, we're not in a position, of course, to decide now, but we're thinking that it might be possible that this matter might come back before us as early as the week of the 17th of November. And my Lord Justice Fraser requests all of the skeletons and the further notes and the notes on notes and this schedule in Word, if that's possible.
Yes, of course. Gladly. Thank you very much. I'm much obliged.
Thank you very much indeed, and thank you both to you, Mr. Leonard, and to Mr. Gold, who has explained a very troublesome and difficult situation. And we're grateful for the way in which this matter has been, this very difficult matter has been presented. And so thank you very much, and thank you for all of those who have appeared pro bono, because this is a very important issue, and it's not a small matter to deal with something like this on a pro bono basis.
Melanie, may I just echo that in relation to my own junior, who has done a vast amount of work at very short notice. And indeed, I know my learned friend won't mind me telling, the court spent an hour and a half on the phone to Mr. Gold this early week, explaining why the schedule said what she said.
Well, it was quite clear to the court that everybody has benefited from the good and hard-working relationship between Miss Elves and Mr. Gold. That has come over loud and clear to the court. I can't recall the last time a leader paid more repeated tribute to his junior than you have this morning.
I couldn't live with myself if I hadn't done that.
And so we do thank you all, and we're very grateful for the effort that you have put in trying to untangle this very, very serious mess. And Lord Justice Fraser has also reminded me that we also note the forbearance of the appellant over this very lengthy period of time. And I'm sure that will come out also when we read her position statement, if I could put it that way. But we note that and the way in which she has remained has remained dignified throughout this very lengthy and unfortunate process.
I'm grateful. Thank you.
Thank you.
All in favour?